Commissioner Phillips, thank you. It's really great to be with everyone and great to be here today. Judge Wallace is one of the good guys in the Ninth Circuit. No, it's a lot of fun. I practiced law up in Seattle, Washington, and did primarily Indian treaty litigation and spent a lot of time representing about 250 shellfish farmers. And what's interesting about shellfish farmers in Washington is very much like what you'd see here in terms of farming, because when the tide goes out in the south part of the Puget Sound, they're out there with tractors and diking and filling, and it's really sort of fascinating case looking back at the history of the state of Washington. And it kind of got me interested in the public lands and the history of public lands, and had a chance to teach that once I came to BYU. I'm actually, we can go to the next slide. First, I guess before I start, let me just say thanks. Thanks to Celeste for the invitation, to all those who are sponsoring this conference. This is a great group to be in front of, and I'm really honored to be here. And it's frankly with a little bit of trepidation, because this is a group that lives the issues that I'm going to talk about, but lives them every day. And in many ways, you'll all know a lot more about these issues than I do. And that's true also because for the last 7 years and some time before that, I've been in administration at the law school and the dean of the law school. That actually concluded last week. So I'm looking forward to getting back to more teaching. But I think that's probably why Celeste had me talk about the history of the public land. She figured, even if you're out of the game for a while, you can still talk about the history because it hasn't changed. But you all have lived with these issues, and I know when I talk about public lands issues, oftentimes in my classes or elsewhere, I'll start with this slide up here. And for you all, this is not a revelation that, in fact, the states in the West, particularly the Intermountain West, are dominated by public lands managed by the federal government. To a lot of my students, that's a big surprise. And I remember when I first headed off to law school, and I went to law school back in Boston. I sat down next to a woman who'd been an undergraduate there, and you have the standard conversation. You're beginning law school, so where are you from, and where'd you go to school? And I said, well, I'd gone to BYU as an undergrad, and she said, where were you thinking about going to law school? And I named a few, and I said Chicago, and so forth. And she said, well, how come you didn't go to Chicago if you'd been out there already, at BYU? And I thought, this is an educated person, but there's 1,000 miles between Utah and Illinois. But to her, everything beyond the Charles River, that's sort of the great unwashed out there. I mean, and she just had no clue. And she'd have no clue about something like this, but you all do. And so I speak with some trepidation, but I'm okay with that, partly because of our family's motto. My family's motto actually comes from my grandfather's funeral. And he was a Swedish immigrant, had grown up logging the forests of northern Sweden, had joined the LDS Church, and then come to the United States. And throughout his life, he struggled a bit with English and never sort of proved to be a fully Orthodox member of the church. And when he passed away, at his funeral, they'd asked someone to speak, and the bishop, the leader of the local congregation, spoke, and he said, we're here to say goodbye to John Johnson, who did, though not well, the best he could. And so that's our family motto. We do, though not well, the best we can. And I will tell you that we had a family council to try to decide what should be on our, family crest, and that finally won out over some close competitors. Some of those, what were the competitors? That hard work has a future payoff, but laziness pays off right now. Or if at first you don't succeed, destroy all evidence that you tried. And then the one that was closest for our family, eagles may soar, but weasels don't get sucked into jet engines. But ultimately decided on we do, though not well, the best we can. And so I apologize for that today, because like I say, you all know these issues in many ways better than I do. But what I really want to do is go back and describe sort of how we got where we are today in terms of the public lands, and really talk about some sort of first principles of constitutional law that I hope will be helpful as you think about all of the issues that you face. So think about at the time of the Revolution, you had 13 previously colonies, and those colonies all inherited, in a sense, at the time of the Revolution, the ownership and the authority that were held by both the Crown and by Parliament. In other words, those colonies took title to everything that had been possessed by Great Britain, and then had to make decisions. And of course, when we look at our Constitution, we look at the Declaration of Independence, it's not just about the states, but it's about individuals, and it's the people. And so the people were faced with this question once they had declared themselves independent, and that was, what are we now going to do with the land that we own and with the authority that we have? How are we going to allocate it? And their first attempt at an allocation of power and authority came in the Articles of Confederation. The second, the one that we're familiar with in terms of the allocation of power and authority, came in the United States Constitution. And so if you think about the Constitution, the first thing you have to remember, and the third point under here, is that our federal government is a government of enumerated powers. And by that I mean, and I know this is elementary, but that the powers that the federal government exercises are the ones given to it by the people. It has no independent power other than that given to it by the people. And what the people were doing when they created the Constitution, or before that the Articles of Confederation, is deciding how to allocate that authority. And they decided, okay, we'll allocate some to the federal government, and the Constitution is the form that took to say, here's what you get to do, here are the powers that you have. We're going to allocate some to the states, and broader authority was going to be allocated to the states, and some will retain to the people, right? The people were the ones making the decision about where to send that authority. So let me step back to the Articles of Confederation for just a minute, because this becomes important to the public land story, but I wanted to make the point initially about the critical thing to understand is the federal government is one of enumerated powers. When it acts, it has to point to some source of authority. It can't just act on its own when it thinks there's a good idea. State legislatures can. They have what's called the police power. The police power allows them to act and to legislate where they think it's important for the public welfare, subject to some limitations, for example, free speech, free exercise of religion, so forth. But the federal government has to point to power. Well, with the Articles of Confederation, one of the issues that came up early on that is going to be important for the public lands is you had certain colonies which had been given by the Crown, and as part of their charters, land grants that stretched from sea to sea. And because British territories really extended to the Mississippi River, what they did was they extended all the way to the Mississippi River. And you see that in this, and it's really hard to tell in this slide, and I apologize in terms of the size of some of these things. I thought that the screen might be a little bit bigger, and so you'll have to forgive me. But I'm just going to walk over. Can you all hear me if I'm projecting like this? Okay. Yeah, so you have the initial 13 colonies here, and they owned, like Virginia owned land grants that extended all the way to the Mississippi. Georgia, likewise, owned land that extended all the way this direction as a result of Crown charters. And all of the colonies had sacrificed their blood and their treasure during the Revolution. And they're trying to form a government on the Articles of Confederation, and the states which didn't hold lands said, now, wait a minute. We fought, and now you're going to keep all of these lands for yourself, Georgia. You're going to keep them all for yourself, Virginia. You shouldn't be able to do that. We all sacrificed for the common good. You ought to cede those lands to the Confederation, to at that point, the United States, okay? And so ultimately, these other states agreed to cede, Virginia, Georgia, they agreed to cede lands in what are called deeds of cession to the United States. And the purpose of that those deeds of cession was that the United States would turn around and sell lands, privatize them within those states, and they'd make money from that, and that would retire the Revolutionary War debt and so forth, provide income for the federal treasury. But the idea was they were going to sell them, okay? We'll come back to that in just a minute. So you have, as part of the Articles of Confederation, these deeds of cession. One of the things that was critical to the formation of the Union was that these states gave up some of their lands to the federal government. And with respect to those deeds of cession, there were certain requirements that we'll touch upon. One of them was that we were going to create new states out of those areas, and those new states would come into the Union on an equal footing. They'd be treated the same way. We'll come to that in just a minute. So go back to the story of the Constitution and the federal government being one of enumerated powers, listed powers, not infinite powers, ones that have been given to it by the people. Think for a minute about the Louisiana Purchase, which you see, really doubled the territory of the United States. You see that in the middle of the map. 1803, Thomas Jefferson is trying to decide whether to take this territory from Napoleon. Napoleon's eager to sell it to make some money. He's focused on the British at that point. And Jefferson says to himself, if we're going to buy this land, I've got to go find authority in the Constitution. Jefferson looks, and Jefferson at the time, the anti-federalist Jefferson, says, you know what? I can't see anything in the Constitution that allows me to buy this land. And so I'm not sure I have authority to do that. Now, the reason I raise this is it's just to help you understand sort of early on versus where we are today, how we thought about federal power and what the Constitution provided. Here's Jefferson thinking, can I do this? You can't imagine that kind of conversation occurring now with respect to, can we go ahead and acquire this additional land? But he's thinking, I'm not sure I have power. Ultimately, he's convinced that, the Constitution, the people gave to the federal government in the Constitution a treaty power, a power to enter into treaties. And therefore, Jefferson, you can use that power, that treaty power, to acquire this land. He was still skeptical, went ahead and did it, later was happy he'd done it. But I say that only to instruct just a minute on what it means to say, do I have the enumerated power here? Is there anything in the Constitution which allows me to do this? And you see a very different mindset than one we have now when we think about the federal government as just sort of a bigger actor with police power, right? Let's go to the next slide. So I apologize. The text, my guess is you're not going to be able to see, and I apologize for that. But again, so if you start thinking about land ownership, and we'll come back to some of these points, but you'd say, what are the enumerated powers in the federal Constitution? Where in the Constitution is authority given to the federal government to act with respect to lands, right? That's going to be the question. And so you turn to the Constitution, you say, okay, there are a couple of places in there that mention land. One of them is what's called the Enclave Clause. And the Enclave Clause was created, and I won't read through it entirely, but one of the things in the Enclave Clause was to allow them to form a seat of federal government, effectively Washington, D.C., and to acquire land for that purpose. And then it goes on, it says, the Congress shall have power. In other words, people are given to Congress power. The Congress shall have power to exercise exclusive legislation. In other words, all authority, in all cases whatsoever. And then it says, over all places purchased by the consent of the legislature of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. So if you think about it initially, you had these 13 colonies. They controlled everything. They gave authority to the federal government. And the federal government was going to need to form a seat of government, Washington, D.C., and was also going to need to have docks and arsenals and forts. They said, we're going to provide a mechanism for you to do that. You go to the state, you negotiate with the state legislature, and once you negotiate that, you'll have full authority over those areas. So that was the Enclave Clause. You also add a provision in the Constitution. The Enclave Clause occurs in what's called Article 1 of the Constitution. Article 1 is the provision which is giving authority to Congress to act. Article 2 gives it to the executive, the president. Article 3 is about the judiciary. Article 4 is primarily about the formation of states. But in Article 4, there's another provision called the Property Clause, with which a lot of you are probably familiar. And the Property Clause says that Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. We're going to come back to both the Enclave Clause and the Property Clause. We think, okay, on one hand, they give some authority to the federal government in the Enclave Clause to do a few things. They also give some authority to the federal government. What is the nature of that authority? Well, one of them you think it's power to dispose of the lands they had, because remember they'd acquired a lot from the initial colonies in these deeds of cession, so they had to have authority to dispose of them, was given to them. And to make needful rules and regulations respecting the territory. Well, you had territories, and you had to run them as territories. of disposition, where the big goal of the United States is we're going to dispose of lands to private parties. And this takes a variety of forms. Famously, the Homestead Act, and you think about the Mining Act, Timber Culture Act, Desert Land Act, Timber and Stone. I mean, we could go on with these. One of them that I think is important to understand a little bit about are the preemption acts. If you think about what's happening, the United States had set itself the task of, we're going to survey the entire United States, these 36 square mile townships, and we're going to survey it, then we're going to offer it for sale. And yet settlement was moving faster than the survey. I mean, they couldn't get out there and survey it, they couldn't get ready for the sale, and people were settling these areas. And they'd go out and they'd settle and they'd start investing in farms and cultivating. And then the United States would come along and say, now wait a minute, you're squatting here, you can't be here. This isn't yours, you don't own it, and we're going to have to remove you. And there's a big uproar about that. We say, wait a minute, we've been investing, all of our labor and energy into these lands, you ought to do something. The United States solution was to pass preemption acts, and they sort of evolved over time. At first they said, okay, we'll allow you to preempt if the area has been surveyed, even if it hasn't been offered for sale. And then later they said, we're going to allow you to preempt even if we've neither surveyed it and we haven't offered it for sale. Effectively what they said is you come in, you pay $1.25 an acre. If you've done some cultivation on it, you're going to have it. But it's important to understand this because these are instances in which people were out making claims effectively prior to the United States making it available. And so you can imagine people as they moved west thinking, there's going to be something like the Preemption Act for us. If we get out there and we work it, they'll come along and they'll later ratify it through something like preemption. Preemption Acts were designed to do that. So in other words, the United States, through these efforts of disposition, Swamplands Act, the 1916 Stock Raising Homestead Act, 32 million acres of split estate lands. The United States by then was deciding that it wanted to retain the subsurface estate for oil and gas purposes. But effort of the United States, we're going to dispose of it. We want to make sure we're disposing of all of our lands. Let's go to the next slide. Then you really get this is one more example of it, just railroad land grants. I mean, 94 million acres, about the size of the state of Montana, go to railroad companies in an effort to encourage the development of the railways into the West. We read stories, Stephen Ambrose's, or others about the battle between the Union Pacific and the Central Pacific, and they ended up at Promontory Point and drove the Golden Spike, and we think, what a great story about, citizens and a competition, a battle, and working in sort of a patriotic fashion to drive the Transcontinental Railroad. Well, the truth is every mile they laid track for, they're getting 10 miles on either side of alternating sections. And then at least at the beginning, later became 20 miles, and then the Northern Pacific is getting out to 40 miles of alternate sections. And these are significant grants, as I say, enough to cover the state of Montana. If you think about Burlington Northern, Weyerhaeuser, the big timber companies in the Northwest, formed by these sorts of railroad land grants. Let's go to the next slide. So you have this period where they're disposing of it, and then what happens is public policy starts to shift. And the thought is, we want to not just dispose of the public lands, we want to begin retaining those public lands. And at this point, this is post-Civil War. Already you're starting to think of ourselves a little differently in terms of the federal government's power to do these things, worried a little bit less about citing provisions of the Constitution that allow you to do things. But 1872, you get the creation of Yellowstone. Before that, sort of partly the creation of Yosemite in 1864. And the General Revision Act in 1891 allows the president to set aside what are called forest preserves, later national forests, and start to get the creation of other national parks. You get passed in 1906 the Antiquities Act, which is supposed to allow the president to set aside objects of historic and scientific interest, primarily to preserve archaeological sites in the Southwest. Teddy Roosevelt uses it early on, though, to set aside the Grand Canyon and other areas that are more scenic objects. 800,000 acres, and starts on a path that we see today of the president having authority, again, given to the president by Congress in theory under the Antiquities Act to set aside areas. Same thing with respect to wildlife refuges, president claiming early on the ability to declare these wildlife refuges on his own. And so this period begins of a shift from a disposal policy to a retention policy. So you get the creation of wildlife refuges, national parks, national monuments, national forests, all during this period. Now, of course, again, there's some overlap here. It's not that there was a day, 1872, when Yellowstone was created where we said, nope, we're done with disposal. Now we're on to retention. I mean, what's happening is that you're shifting to a policy of retention. Stock Raising Homestead Act 1916, right, is a disposal law. The Homestead Act is still operating at that point, but there's a public policy shift going on. When you think about this period of, you start having this shift towards retention. There's still disposal going on. Then you get, in 1934, the passage of the Taylor Grazing Act, partly driven by the Dust Bowl, which is partly a function of agricultural practices as they moved west, partly a function of what you had on the range is effectively an open commons where people were using up the grass as fast as they could get it. You had the cattle versus sheep folks. And some of these are reasons why the Taylor Grazing Act is passed. We won't spend a lot of time on that, but with respect to the Taylor Act, what does it do? It says, in order to promote the highest use of the public lands, pending its final disposal, which is interesting language, but the Taylor Act is suggesting that, still, this is a temporary solution, right? This is going to be pending the disposal of the public lands. The Secretary of Interior is authorized the discretion in order to establish grazing districts of vacant, unappropriated, and occupied land. So in other words, we give the Secretary authority to establish grazing districts pending their final disposal, and to issue permits for those grazing districts. And then it goes on and it says that these grazing districts are to be created for a period of not more than 10 years, subject to the preference right of the permittees. And each one of these we could spend hours on. Preference of the permittees to renewal in the discretion of the Secretary of Interior. So far as consistent with the purposes and provisions of this subchapter, grazing privileges recognized and acknowledged shall be adequately safeguarded, but the creation of a grazing district or the issuance of a permit pursuant to the provisions of the subchapter shall not create any right, title, or interest or estate into the lands. And so you have the United States as part of this retention policy, in a sense saying we're no longer going to open these up entirely, but pending their final disposal, we're going to divide them up into grazing districts. We'll come back to this in just a bit. Let's go to the next slide. So that's 1934. In a way, you can think of the Taylor Act not entirely as doing this, because the Homestead Act continues on other things, but effectively saying, Timberstone, Desert Land Act, the chance to go up and take up lands is mostly over. We're going to divide them up into grazing districts. We've already set aside national forests and national parks. Now we're going to enter what most historians talk about, this era of management. We're managing what we have. That begins, they say, in 1934. But remember, the Taylor Act suggested that it was done pending final disposal. But in 1976, Congress passes a Federal Land Policy Management Act, FLPMA, with which I think you're all familiar. And FLPMA changes from the Taylor Act. It's no longer pending final disposal. What FLPMA does is it says that the policy of the United States is that the public lands be retained in federal ownership. Okay? So it changes federal policy from one where we're dividing up into grazing districts pending final disposal to we're going to keep them. It said that the lands we're going to keep will be managed for multiple use and sustained yield, which is standard for both BLM lands and Forest Service lands. It also provided for the Bureau of Land Management to conduct a wilderness inventory. Some of you recall the Wilderness Act, which was passed in 1964, found wilderness within national parks and created instant wilderness within national parks, a few within national forests. It required them to go look within national forests and parks for more, but didn't do anything with respect to BLM lands. FLPMA says, now we want to look for wilderness on those BLM lands, and starts that process as well. Management on those BLM lands is going to occur under land use plans, resource management plans as we know them. One way we'd look at it would be to say, okay, under the Taylor Act, you have a shift to management, but at least by 1976, when you say our policy is to retain them, one could say that you've entered clearly then this era of management. I want to go to the next slide, and frankly, this is an entirely separate talk, but it's interesting to me, if you look at outside of Alaska since 1964, the land managed by the primary federal land management agencies, Fish and Wildlife, Forest Service, BLM, and the National Park Service, it's increased by 20 million acres since 1964. And so if we think about, is this really an era of management or in fact an era of reacquisition? I mean, 20 million acres is just more than the size of the state of Maine. I mean, some of this is land exchanges, some of it is purchases under the Land and Water Conservation Fund, but pretty significant change to the federal landscape in terms of reacquisition. And I think we could say we're in a period of just managing what we have, but in a way, the federal government's in a period of acquiring more lands. And another way to think about this, if you think about the Endangered Species Act and habitat conservation planning, or if you think about Section 401 of the 404 of the Clean Water Act, which requires a dredge and fill permit, you're sort of reacquiring things you'd granted away under the swampland grants. There's a lot of reacquisition going on in a way. So, footnote on that. So this is where we sit now. I mean, primarily private east, public west. We can go to the next slide and think, why is this the case? Why didn't more of these lands get taken up? Some of it was a shift to a policy of retention, and some of it, frankly, was that they were the lands no one wanted for a period of time. That's how they were described. And why didn't anyone want them? Well, they're beyond the 100th meridian, where there's less than 20 inches of rainfall a year, and so absent irrigation, you weren't going to be able to use them for agriculture, and so they were taken up less. And you all know that, but you just see this picture of where the water is, and it tells you something about where the public lands are going to be in terms of what got taken up. Let's go to the next slide. So, let me look at this question for just a couple minutes. I mean, and that is, if you think about, that was sort of a quick description of how we got where we are, in part, with respect to these eras of public land management and acquisition, disposition, retention, and now management or doing some reacquiring. What if you want to see a change from that status quo? What might challenges look like, legal challenges to federal ownership or federal regulatory authority look like? What form can those take? How effective might they be? What are the hurdles to those types of challenges? And I think it's important to understand the hurdles to legal challenges and the path they can take, because it helps you think, okay, well, if that's going to be that difficult and that costly, maybe we ought to be looking at other options. So what are available legal challenges, and what are the ones you can even think about to federal ownership? So let's go to the next slide. So again, I want to come back to the slide that I showed you before, and this is with respect to the federal government's enumerated powers. One argument, whenever you say, any time you say, hey, Congress, you shouldn't be doing what you're doing, United States, you shouldn't be doing what you're doing, is you say, you don't have the enumerated power to act here, okay? Think about the argument, which ultimately proved unsuccessful, but with respect to the Affordable Care Act, which was to say, look, the Commerce Clause, which Congress has authority under the Constitution to regulate commerce. The argument is the Commerce Clause doesn't give you this authority, Congress, to mandate the purchase of an insurance product. You can't do that. Not allowed under the Commerce Clause. Ultimately, you get 5 votes in the Supreme Court that agree that the Commerce Clause doesn't give Congress that authority, but its taxing power does, is what Chief Justice says. But again, same sort of argument, right? You can't do this because you don't have enumerated authority. So what do those look like on federal land? You say, what is the authority of the United States to retain federal lands and to exercise authority over them? Do I have an argument there? Can I make an argument they just lack the authority? There's nothing enumerated in the Constitution. Well, usually we make that argument and say, okay, look, the Enclave Clause is the statement of authority. In fact, the Enclave Clause occurs in Article 1 of the Constitution. Article 1 is the listing of congressional power. Property Clause occurs in Article 4, which is primarily about the creation of states. But you say, look, federal government, you've got authority. That authority is the Enclave Clause. That allows you to negotiate with states and establish enclaves. And that ought to be the full extent of your authority. It says right there in the Constitution. Well, so it turns and says, wait a minute, what about the Property Clause? The property clause says that we've got the power to dispose of and make all needful rules and regulations respecting the territory or other property belonging. They say, well, what is the property clause intended to do? Well, one of the things it was clearly intended to do was to give the United States authority to deal with those Northwest territories and those lands that have been ceded by the initial states. And you think, okay, was it designed to give them authority over the additional territory they acquire into the future? Yeah, probably so, because how else are you going to manage those territories? I mean, the original states are looking and saying, what are the rules we're going to create for those territories out there? We've got to have authority. Congress has to have the authority to set up rules for those territories. It doesn't deal with when they become a state, but it does deal with when they become a territory. What about this or other property belonging to the United States? Because it suggests, okay, you've got authority over territory and over other property. What are those other properties? Well, one way to think about the other properties is to go back to the example of the Live Oak Reservation. Well, there are some times where you need, or take another example. The Article 1 of the Constitution gives the authority to Congress to create post office and post roads. And you'd say, hey, if we have authority to create a post office, is the only way we can do that by the state's permission? Because the people already gave us the authority to create post offices and post roads. We must have, as a necessary adjunct to our power to create post offices, the ability to acquire land for that purpose. We must have, as a necessary adjunct to our ability to raise a navy, to acquire this Live Oak Reservation so we can have oak and cedar to build our ships. And so he'd say, well, the necessary and proper clause gives us the authority to acquire land as necessary to accomplish our other enumerated powers. That's one view of what that means by other property. There are really a lot of arguments around this. Another problem that, I don't know if it's a problem, but you think, we'll talk about this in just a minute. I mean, you think about a case like Kleppe versus the United States, where the court says that the authority of Congress over the public lands is effectively without limitation, unlimited. That the United States has effectively what we call police power, the same power as a state has over the public lands. And you think, how does the court get there? How does the court get to a position where it says that the federal government has unlimited power with respect to the federal lands when you've got an enclave clause? Because why would you need to put an enclave clause into the Constitution at all if the United States had authority to condemn or take public lands, keep or purchase public lands, and if it could exercise unlimited authority over them? There'd be no need ever to negotiate an enclave if you could have unlimited authority. And so you think, clearly, it can't be unlimited over those lands because you've got an enclave clause which suggests that when you want unlimited authority, you go and negotiate it. And yet, by the same token, why would you have in the property clause a reference to the ability to make needful rules and regulations respecting the other property if the enclave clause was the only way to do it? You think, well, the enclave clause is the path for that, so there shouldn't be this other property references. So there's some ambiguity and tension here, but I think if you look at the constitutional text and the provisions sort of early on, you can think, look, the enclave clause is going to be the primary vehicle for the United States to own land, except in the territories where it has to make rules. And then after it becomes a state, well, the obligation is going to be to dispose, and then they get to retain some other property to the extent necessary to accomplish other enumerated powers, not just to retain. It's a pretty plausible argument. Let's go to the next slide. But why is that a challenge if there's a plausible argument to say, look, there's nothing in the Constitution gives you this authority? Well, the challenge is that for now 170, 180 years, the Supreme Court has gone the other way. And aside from a couple of outlying cases, mostly what the Supreme Court has said is, and you're not going to be able to see these, and it really doesn't matter that much, but there's unlimited authority for the federal government with respect to the public lands. It can do with them what it will. That the right to dispose includes the right to retain. There is United States versus Gradio was a question of federal leasing of lead mines in Illinois, and they said, yeah, the first challenge was when you lease them, you're retaining them. You're supposed to be disposing of them. The court says that's okay. I mean, they're allowed to retain them. Light versus United States, the third one. This was a dispute that happened just soon after the creation of the forest preserves. Gifford Pinchot, who was put in charge of the Forest Service early on, started to charge 5 cents per AUM for grazing on forest preserves. Ranchers in the Holy Cross Forest Preserve said, wait a minute, you have no authority to charge us this. That's not part of your enumerated powers. And challenge goes up to the court, and what happens, the ranchers say, we're not going to pay that amount. We're not going to pay the 5 cents per acre. Comes to the United States Supreme Court in Light versus United States, and the court says in Light versus United States, the United States can prohibit absolutely or fix the terms on which the property may be used, as it can withhold or reserve the land. It can do so indefinitely. Then it says the same thing in Kleppe. It said the same thing in a lot of cases. So the challenge is that while you have constitutional text that I think gives some arguments for the fact that the United States doesn't have enumerated power, it's really difficult to make those arguments given this long chain of Supreme Court precedent. Let's go to the next slide. So what about the equal footing doctrine? Does that do the job? And I ask the question here, does the equal footing doctrine otherwise limit the enumerated power to retain? Again, think about it this way. Federal government has to point to enumerated power in the Constitution, say, here's where we've got it. Here's what allows us to do this. The Constitution not only lists powers they have, but it also lists some things they can't do. I mean, you think about the Bill of Rights. And so you may have power to regulate interstate commerce. So, for example, you get to regulate airplane traffic. But you don't necessarily have power to regulate airplane traffic by saying all of our plane flights will be segregated by race, right? You don't have that authority. And so on the one hand, you have enumerated authority, but it's limited by another provision of the Constitution. That's kind of how the equal footing doctrine would work. Even if you have authority to manage, that authority over the public lands is limited by your obligation to assure that each state enters the Union on an equal footing. Now, where does this equal footing doctrine argument come from? We've described it in part, but mostly it comes out of an 1845 United States Supreme Court case called Pollard versus Hagan. Pollard versus Hagan was a dispute about ownership of some tide lands, some submerged lands in the Mobile Bay of Alabama. It's a shock today, but Justice Catron, who actually wrote a dissent in this case, says the most important case ever to come before the court at that point, 1845. And you're thinking, really? About ownership of a tide land in Mobile Bay? But here's why it was important. I mean, what the court said in Pollard is that the United States has an obligation to dispose of all of the lands it acquired in the deeds of cession. And that in order for Alabama to enter on equal footing, it had to get rid of those lands. The United States, it said, had no municipal sovereignty. In other words, it had no police power over its lands. It only had the power really as necessary to take care of business and sell what it had been given by the state of Georgia. Once it was done, it should have been out of there. This is what the court effectively says in Pollard. And you think, wow, that's a pretty powerful version of the equal footing doctrine, that the United States has this obligation to dispose of lands within a state so that the state can enter on an equal footing. If you can read that from your distance, you're better off than I, because I can't read it from here. But you see a lot of citations to Pollard, and you think, can Pollard win the day? It's a tough argument to make. Why is it difficult? One of the reasons that it's difficult is Pollard was talking about lands that had been deeded by Georgia under which there were specific terms that they dispose of them, as opposed to lands that later came in that the states had effectively purchased under the treaty power and took to the west of the Mississippi. And so Pollard, in some sense, is limited to lands that had to do with deeds of cession. Another problem is that the statements about the United States' obligation with respect to land are what generally we talk about as dicta. And by dicta, what I mean is that they're statements that are not necessary to the decision. And just take a sort of a silly example. Garden variety dispute, that somebody is driving along and texting and not paying attention and injures another party. They get sued and they say, hey, you were negligent because you weren't paying attention while you were driving, you were texting. And the court says, yep, clearly you were negligent, and writes the opinion saying they're negligent, and says, and you know what, it's not just texting that's the problem, it's drunk driving. And I'm going to write a separate page or two about the problems with drunk driving and how we ought to now have a rule that if you take 2 drinks, you're negligent. And so the court is sort of giving us their advice about what a drunk driving case ought to look like, but that's not the issue before the court. Okay? The problem with Pollard partly as well is that the issue in the case was what's happening with these submerged lands, and the court ultimately held that the United States couldn't dispose of those submerged lands. And so you think, well, wait a minute, if there's an obligation to dispose, how in the world can you get a decision that says you've got to keep those lands? Well, lands under navigable water are treated differently because they're more bound up with sovereignty. But in any event, the problem with using Pollard is partly, hey, that was a case about land under navigable water, not about what we call fast lands, dry lands, however you want to refer to them. And so when we use Pollard, we're really talking about extra statements, the drunk driving statements from the court. The other problem, what have the courts done with Pollard? Well, over time, they haven't followed that part of Pollard. Some parts of Pollard still survive with respect to lands under navigable water, but Shively versus Bowlby, Scott versus Ludig, United States versus Texas, or Ladig, United States versus Gardner, the Nevada case that some of you may be familiar with, over and over, the courts have said, look, equal footing doesn't apply to land ownership, it applies only to political sovereignty, and so they've rejected the Pollard dicta with respect to ownership that the United States is required to dispose and may not retain the public lands. And so, again, you think, well, Pollard, that seems pretty plausible in view of the Constitution in 1845 when it was decided, but the courts have moved the other direction over time. And so all that precedent really erects a barrier or a wall to using equal footing arguments. It makes it really tough because you're trying to overcome 150 years of court cases, even if when you look back and you say, wait a minute, the Enclave Clause, the Northwest Ordinance, equal footing, the narrow scope of the Property Clause, that's really the original understanding of the Constitution. The courts have sort of moved. What's another vehicle? Well, you go to the State Enabling Acts. And remember, we looked at these briefly, and you look at the proceeds clauses in the State Enabling Acts, and this is what Utah has done. And it passed it's called HB 148, but it's their Transfer of Public Lands Act. And what it does is it requires the federal government to give back to Utah its public lands by December 31, 2014. So that date is come and gone. But except for national parks, national monuments, wilderness areas, and lands previously ceded for military use. Now, I suppose if you look at that list, you think, well, why are those exceptions? Because under the Constitution, they shouldn't be keeping any of it. Well, some of it's political, right? I mean, in terms of what can you afford to demand. What's the last one from? Lands previously ceded for military use? Well, that's the Enclave Clause, right? Because those would have been ceded under the Enclave Clause, and so that's why you see that there. And then they say, and with respect to those lands that are transferred and subsequently sold by the state, we promise that we'll give you 95%, and we'll keep 5%. Where does that come from? Well, it comes from the Enabling Act and that initial proceeds clause where the United States said, we're going to dispose of them and we'll give you 5% of the proceeds. Utah's effectively saying, you know what? You got to give them to us because you promised you were going to sell them and you didn't sell them. We want to sell them. We'll give you the 95%, and we'll just keep 5%, but we've got to be able to have the authority to sell them. Okay, and so you think that's a pretty good sort of contract type of argument, right? We entered into a contract with the United States in the State Enabling Act, and you failed to follow it. You said you were going to sell it, and you were going to provide us 5%. You didn't sell it. Do it, okay? And we're going to require you to transfer the lands to accomplish that. What are the challenges for that argument? What are the difficulties? One of the challenges is that the language in the Enabling Act says that 5% of the proceeds of the sales of public lands lying within said state, which shall be sold by the state subsequent to their admission of said state, which shall be sold by the United States subsequent to the admission of the state into the Union, shall be paid to said state. The challenge then in part is like, what does this language that I've highlighted in yellow and we can't even see, but when we say, which shall be sold, is that a command that the United States must sell them? I mean, I think everybody believed that the United States was going to dispose of them at the time Utah's Enabling Act was passed in 1894. But is this an obligation, because it says shall be sold, for the United States to sell, or is it an obligation to provide the 5% for everything which shall be sold? In other words, once it's sold, you've got to give 5%, but does it obligate one to sell? That's going to be a source of argument. How should this be read in connection with a disclaimer clause in Utah's State Enabling Act, where you disclaim all right, title, and interest? I mean, one argument, the state of Utah, well, wait a minute. If we have to disclaim all right, title, and interest, that puts even a greater onus on you to turn around and sell the others so that we can actually get the 5%. But the biggest hurdle, I think, is going to be, you think about how have courts interpreted in the equal footing context or in the context of federal authority over public lands, CLEPI and Light and so on, how have they interpreted federal power over the public lands? What's happened? And so what interpretation are they likely to give to Utah's Land Transfer Act or to the Proceeds Clause? Are they likely to give an interpretation which prohibits the United States from retaining those lands, where there are so many cases out there which suggest they can retain them? My sense is that's going to be a fairly high hurdle given where the courts are now. And again, you look and you think, pretty close argument under the Enabling Act. But I think a hard argument given what's happened with the courts over time, just to recognize those hurdles. Let me just take one more thing, and then I've got to stop because we're going to be up against it time-wise. Just sort of a small point, a background point, as you're sort of having the conversation through the rest of the day on some specifics, and that is this. I title this, Ownership is Only Part of the Battle. And I put a picture of a road here. This is a picture of the Burr Trail in Utah, a very famous RS-2477 road. And the United States, as part of the mining law of 1866, said that, you see it there, that be it further enacted that right-of-way for the construction of highways over public lands not reserved for public uses is hereby granted. And there's a lot of time and energy devoted to trying to acquire the property right. The tough thing, and I think sometimes the frustrating thing, but something that's critical to keep in mind, is that even if you have the property right, it doesn't mean that you have complete control over that property. Because let's say, take the Burr Trail, where in fact you have a property right. But if you have wilderness study areas on either side, or you have Capitol Reef National Park on either side, you have the federal government asserting its authority to regulate, not just under the Property Clause, but under the Commerce Clause and under other sources of federal authority, to say, we get to regulate what you do. And so, as you think about the ownership question, it's always important to be thinking not only about ownership, but also about regulatory authority. And then, okay, I may gain the ownership, but then what happens with the regulation? And to keep an eye on both of those balls as we have discussions about what solutions are. I've got to stop, but to me, part of the story is that the same story we see in lots of areas. You have constitutional text, which creates a pretty strong argument. That would be true, say, under the Commerce Clause as well. But then what happens is that law moves over time, and over 150 years, and that's been what that does. All that precedent, that Supreme Court precedent, erects some real barriers to getting back at some of that constitutional text. And that's not to say the constitutional text is absolutely clear. There are arguments on the other side of it, but it's hard to get there when you have these layers of Supreme Court precedent. So it's just a quick view of some really, I guess, some basic premises of public land law. I hope it's helpful to laying some foundation for the discussion today. I will just look forward. I know we're up against it time-wise, but just having conversation with all of you during breaks and spending some time together. So thanks very much for letting me be here. I have 4 minutes? Okay, 4 minutes, great. Yes? Yeah, I'd be happy to. In fact, I could provide it. You could shoot me an email and I could send it to you, or what I could do is I could just give it to Celeste, and then Celeste could distribute it. But yeah.
And my email's on the website where you all registered.
So if Celeste is on the website, I'll give it to Celeste, and then you're welcome to have at it. Yes?
I'm sure you're familiar with the legal analysis that was done for the legislature in Utah. What's your opinion on that, just briefly?
So the question, thanks. The question is that there was a legal analysis. The state of Utah hired several attorneys to do a legal analysis of the likelihood of success in litigation under the Transfer of Public Lands Act. And what's my view of the likelihood of that opinion? Now, I've read it quickly, and so I really can't speak to the details of it. My general takeaway from it, though, was that they were probably more optimistic than I'd be about the chances of success. I thought that the legal arguments that are articulated and its comprehension of the issues was really strong. Its conclusion about, and it didn't even say that there was, a likelihood of success, but more of a possibility. I thought they were probably a little optimistic even in that. given what I see as the sort of long run of precedent, that it's a tough case.
Well, I think they did say that there was a likelihood of success. I was there for the rollout of it, and that's the way it was presented.
Yeah,
What I read.
I'm less optimistic than they are with respect to the likelihood of success. I thought the analysis from what I looked at, though, in terms of the comprehension of the issues and the recognition of the problems and the arguments they'd make was strong. I mean, it was good lawyering. I think the conclusion was more optimistic than I'd be, is the fairest way to put it. There was a hand back here and then here.
So, you say the most likely aspect would be a congressional act to get some of these lands released? I mean, it doesn't sound like they're really.
Yeah, I think it's hard to do it through litigation. My sense is that it's partly about political leverage. It's partly about getting Congress to act. I mean, it's partly these efforts at, whether you think about Representative Bishops or others, who are trying to work for solutions that divide it up and reach better outcomes. I think that litigation route, sometimes litigation is part of a political strategy, right? And so it's not necessarily irrelevant, but I think to bank a lot on its success wouldn't be, in my view, fair. Yeah, go ahead.
I was just wondering, what's your legal opinion of what are the grazing rights entitled to permittees on Forest Service and BLM grounds?
That's a big question, right? I mean, the Taylor Act suggests that there's no right, title, or interest, but then you think, okay, well, what does that mean? It has to adequately safeguard grazers' privileges. So what does that mean with respect to the underlying preference, for example? I think there are additional questions about, what constitute improvements. You have really interesting, the Hage case here with respect to rights of way and water rights that are associated with those rights of way, or ditch rights associated with that, and whether there are property rights in those. But typically, if you think about a right of way, its purpose was to get you somewhere, and if you don't have a right to what you're getting to, that right of way itself starts to lose value. So I think that I'm getting the time signal here to don't you wish you could have done?
We can talk after.
Don't you wish you could have done that in class? Just say, you are done. That'd be really convenient with every faculty member. Anyway, again, thanks so much. We can spend more time talking about that, but I will stop. We're up against it time-wise. And again, thanks so much for letting me be here. I look forward to the day.